Oh dear. Let's see if we can get this happening. Okay, apparently I'm live. Sorry for being AWOL, but there's been an issue where I had a bit of an accident and I haven't been able to sit down. Nearly ripped my leg off, so it's starting to get better, but it's still weird. Look, I'm going to change the camera a little bit while I'm just sort of setting up. I've ordered a new one. This was the only one that I could get in the pandemic thing, and it's just it's driving me nuts. It's widescreen and it should be straight on, and it's not, and it just bugs me. So anyway, before I get started on talking about, the information overload when people come to talk to me, I just thought that I would play this phone message that my husband got a series of. If you're in the Mandurah area, be aware they find you here too. So I'll just play this one.
Customer service. We have seen a recent order number, AMG0987, of iPhone 11 Pro on your account, which is billed on your card attached to your Amazon account. The amount charged is $1,499. We noticed some suspicious activity on your account, so we have put a hold to this transaction. Please press 1 now. And to report, please press 2. Thank you.
And there's another one.
That your Amazon Prime account will be auto-renew for $39.99 from your bank account, so enjoy using Amazon Prime services, or if you want to discontinue or unsubscribe to services, then speak to an Amazon service manager by pressing 1.
Yeah, look, I'm going to leave it at that. So obviously my husband doesn't have an Amazon Prime account. I do, but it's like $6.99 a month. And, anything, if you do have an Amazon Prime account, you just log into your account and you sort it there. But this is a scam going around, and surprisingly they used a private phone number to phone my husband, so he wouldn't be able to return the call even if he wanted to. And he's got a policy, if you've gone to the effort of making your number private, he's not going to answer it. Leave a message with your phone number and he will call you back, but only if he actually thinks that it's legit. So he would never return the Amazon mob call anyway. So it's a scam, and what usually happens is if you press 1, they direct you to download an app onto your phone, and then you log in and you give them all of the permissions, and then they get your bank accounts. So if you or anyone you know has received one of these calls and downloaded the app and followed the instructions, get a hold of your bank. I know that ANZ has been made aware of it from somebody in Mandurah, because I'm on the Facebook group for Mandurah, one of them, and they do put out this information, like, she took her mum straight to the bank and the bank's now aware of the scam. But they can take thousands out of your different accounts, because once they've got access to your bank account, they've got access to all of them. So just be aware it's a scam, and it's now targeting people with mobile phones. They used to only target people with computers and, do the internet scams that way. But now they're convincing people to download the app onto their phone, and from that they've got access to everything, which is scary. It's a scary thought. So because I haven't seen how the phone scam unfolds, I'll put a link into the description for all of there's a few YouTubers who do the scams. They expose the scams and they play with the scammers, so I quite delight in that. And I think all governments around the world really need to, stop these people. They are thieves, they're criminals, and they take people for a ride. And I mean, they must think that people in Australia and America are all made of money, and the truth is most aren't. There are people who are extremely well off. There's also a lot of people who've got bugger all. So we'll just go with that. And if you're from overseas and you get offended by the term bugger, in Australia it's got a different meaning, so don't worry about it. It's bugger's like, oh damn, or a few other choice things. Anyway, I'll get on with what I really want to talk about. Now, I have sort of mapped it out in my head, but I don't have a running sheet of what I want to talk about when, because, well, no subscribers, no one listening. I just want to start streaming every day now that I can sort of sit up again. It's not quite comfortable, but I can do it again. So there's, like when you're taught civil procedure, there's a beginning, a middle and an end. So most matters start with a letter of default being sent to someone, or, a cease and desist order, or, something. You've done something, I want you to stop doing it, or I want you to fix the problem. Banking matters, it's a default notice, a letter of demand, and then the default notices, ours went on for a long time. It depends on how the bank wants to handle it. They tend to do 3 or 4 default notices. They will try to help you. And when I say they will try to help you, cynical me knows that sometimes the way that they help you is to really help themselves. So, they might get you to sign a deed of forbearance so that, this helps you. Don't ever sign a deed of forbearance because it doesn't help you. It helps them in their final case against you, and honestly, you're screwed. But that's usually how it starts. You start with a small action and then it builds. And then, they'll start the proceedings, and they'll usually start with a go at a summary judgment if you haven't rectified the fault. They've tried to sort you out, and they've tried to negotiate with you. Then they put in documents to get summary judgment against you. Say if it's a mortgage involved, they actually want your property that's mortgaged and any assets that you've put in support of that. And usually they go overboard. But with a really big mortgage, they then justify it by saying, well, we might not get enough for this particular property, so we want to take all of the ones that we've put security over. And then, a lot of people fall down at the summary judgment because you've signed a contract, you haven't paid it, you're in default, you can't do it, and you're out, you're blown out of the water. And depending on your lawyer, some lawyers actually look more deeply at the documents and your story, and they sort of try to put together, well, what's your defence? How come this happened? And there are some very clever lawyers who actually find where the bank did the dirty on you, whether it's outright fraud or whether it's just, misleading and deceptive conduct, or if it's unconscionable conduct. You can then have a defence and a counterclaim, which if it's persuasive enough, the court can't give summary judgment, so it then gets slated for trial, and then all of the evidence comes out, and it's a really long process. And then, you end up having the final decision, which normally goes in the bank's favour. But a lot of the time, you're stuck with what your lawyer decides. And if you haven't sought legal advice and you're self-representing, you often go with some of the things that you've read, and you might miss some critical things that would be in your favour. And then you end up with a result like our result was because of our lawyer and the decisions that the lawyer and the barrister made. There was a lot of background stuff happening that we weren't aware of, and we basically were blown out of the water because of this cute little thing called the Anshan estoppel. And the Anshan estoppel is a doctrine where if you had information, or you had the relevant information and you didn't put it to the court at first instance, like right at your first hearing type thing, or you didn't refer to it at all, you didn't try to bring it in as evidence, or to prop up your side of the story, you can't then later go back and say, yeah, but look, I've got this piece of paper. If you had that piece of paper before the first court hearing, or it came up during discovery and you didn't refer to it, you didn't draw the court's attention to it, well, that's bad luck, because the court doesn't want to re-go over everything. The only time that it's pretty hard, if on its own it wouldn't prove more of your case, and then you get the other information that ties it in and shows the importance of that document, you might be able to put it in later, but it's really hard. And I mean, we were screwed over by the Anshan estoppel because we simply couldn't use the information that was already in the bank's affidavit at the time of the summary judgment hearing. So when I say we were screwed over by our lawyer, I mean the lawyer didn't see the significance of the document and didn't ask me about it. And it's kind of my fault, but in my defence, at the time when we received this 184-page epic affidavit, our son was in hospital dying. Now, he recovered, everything's fine, he's still got lots of health problems from this, but I wasn't in a place where I could concentrate on a 180-odd page affidavit. I said to the lawyer, you read it, anything comes up, let me know. And I mean, after we lost everything and we were in exile in Perth, I went through this because the law firm sent us an invoice, and I'm like, hang on a minute, they've already charged us for that, they've already charged us for that. Went over all of the invoices and we were charged, for finding the same single case. Our lawyer relied on one case and one case only. We were charged 3 times, $600 to find one case. I'm thinking there's something wrong there. And we were charged about $600 for him to research whether he could put in an appeal out of time. Now, we told him to put in the appeal. We instructed him to do it immediately, and he just put it off. And it wasn't until I went to one of the news channels, and they interviewed me, that he actually decided to put this appeal in. So our appeal was filed out of time. There were a lot of documents that were out of time. So when I say this happened to us, I'm speaking from experience, and the reason why I became a lawyer, and none of this here is legal advice, but I became a lawyer. I did the law degree so that I could figure out how to help people like me so that they don't find themselves in the fun situation we're in, where, we're looking down the barrel at my husband retiring, and we've got more debt than we've ever carried. And that's because house prices went up so much. I mean, at the time that we were taken for everything, our original mortgage was running at $141,000. We would have paid that off in the last 11 years, even doing minimal payments and whatnot. We were thoroughly screwed over, so I want to help people like me. Anyway, back to having the information on hand and not using it. Because people who haven't got a law degree, and it took me quite a while to really wrap my head around how this whole legal system works and how it kind of can be skewed, is because it's too complex. And if you don't think like a lawyer, which why would you, then you're likely to miss some of the things that are in your favour. And so you may not put all of your case to the court if you're self-representing. And I mean, how do you know how to instruct a lawyer? I think it's actually an art to be able to instruct a lawyer, because I've read a lot of case law now where I think, why would they have done this argument? Why not that argument? And I can tell you, I'm not a practicing lawyer at the moment. I have my practicing certificate. I'm on the roll of practitioners, but I'm not working as a lawyer, and I'm very inexperienced. Happy to admit to that. I mean, it wasn't like I was a spring chicken when I got my law degree, but there are so many different ways to go. So what's the best way to go? Because you can throw every legal argument at this, but some of them have very low benefit. Some of them are more cost effective than others. Some of them are easier to prove. There's a whole range of things, and you can do a defence. You know, this is our main defence, and in the alternate we plead. You can do that, but how many different ways do you want to go? For every argument, it's going to increase your costs, that kind of thing. So there's a lot to this. And then, of course, you get the appeals process, and then you can appeal from, say you're going through the Supreme Court of Western Australia, you can appeal that decision to the Supreme Court of Western Australia, and if you fail at that appeal, you can take it to the High Court, and you might get a hearing. It's really hard to get a High Court hearing, but, you know, self-represented litigants have gotten up to have their case heard by the High Court, so that's not an issue. So that's the background for, you know, that's how normally things go. You start and, you know, you keep moving. Now, what I find myself in, the position I'm in now, is I'm contacted by a lot of people who had initial legal advice and things went pear-shaped, or they've never had legal advice. They started proceedings on their own, or they defended on their own, and things kind of went skew-whiff, and they don't understand the legal arguments the other side puts out. You get tripped up by the language. Common words may not have the same meaning in the law, and sometimes they think that a common word has a different meaning in the law. So it gets really complex, and by the time they talk to me, I know that one guy who's seeing me at the moment, I've put together the documents for him to instruct a lawyer. He's had a whole lot of case law before that's connected but not directly to his current matter. His current matter has been on hold for 2 years. The court said, look, come back when you've got the time, which to me seems really odd, but I asked him to check that he's still got time, and he says, yeah, they've come back with that. The lawyer who's seeing him now seems to think that that's correct. But because it's so convoluted, and the guy has been in this system for so long with the various things that happened, and it's a really messy case. There's so much information. You suffer from information overload. And it took me weeks of reading through some of this stuff and actually seeing what happened when, and what information can be used and what's excluded because of the Anshan estoppel. And it did my head in. And this isn't a banking matter, so this is something else again. But the principle's the same. You know, somebody shows up, and I mean, this guy's got 6 boxes worth of the big folders, so it's like 6 boxes of paperwork. And yes, he's organised them, that, you know, they're all in their own different tabs, but there isn't an index on all of those, and there's not a description of what's in the document and why it's relevant. And there seem to be some documents missing, and some of them have been broken up, and the emails refer to attachments, but the attachments aren't with the emails, they've been filed separately. So it's really hard to know what happened when, what information was available when, and really sorting it out and putting that into a document that he can hand to a lawyer. And I mean, I did it. And when you do a document for a lawyer, to sort of say, have a look at this, I think this person's got a case. I can't, you know, put much into it, and I don't get paid for this. So I'm not charging anybody for this work, so which is why I'm sort of starting this YouTube channel. And I'm going to do the Patreon account so that I can get paid for it from, you know, a whole lot of people rather than one person who's already, you know, if you're in trouble with financial stuff, you don't have the money to pay for a lawyer. You know, if you had the money to pay for a lawyer, you'd have the money to bail yourself out. It's as simple as that. So from that, you know, you end up with this mess of things. And if you're self-representing and you've got all of this history, can I sort of suggest that you have, if you've got the time, and just remember that the deadlines, you've got to meet the deadlines. Sometimes you can get an extension, but I think you need to step away from all of it for 2 or 3 hours a day, every day. Have time out where you don't think about it, you don't dream about it, you just do something to take your mind off it, because I think sometimes you get lost, and I think you need to get back into, what have I done? What was the result of what I've done? Is there anything I'm missing? Is there anyone I can reach out to for help? And if you've already had legal advice, it might be an idea to go back to the legal advice and reread what they said. Sometimes it really helps to go back over documents. I know that sometimes on first reading, second reading and third reading, I get an impression of one thing, and then I'll put the document aside, and I come back 2 or 3 days later and I'm there, oh, I never actually picked that bit up, because we get into our own story. And I noticed that especially when we were going through this. The lawyer would come to me with a question and he would tell me the reason for the question. So automatically, as soon as he does that, I'm thinking in a certain way. Whereas had it been more of an open question, he would have gotten more information. And I mean, he ignored most of the information I gave him anyway, so it's pretty irrelevant. And don't worry about it, you won't run into this guy. He did the dirty on a very, very rich man in Western Australia and won't ever practice again. So I wasn't the only person to have a bad result with him. And yeah, he got in trouble with the legal practice complaints committee. So yeah, he won't be bothering anyone else again. But lawyers try to do their best, but you've got to remember they're time poor. They have a lot of stresses on them, and your case isn't the only case they're working on. I've got about 3 or 4 people talking to me at the moment where what they need is a bit of an overview of their case, just sort of put it together into small chunks so that when they instruct a lawyer, it's already chunked out for the lawyer. And then, you put a list of really important documents followed by other documents followed by other documents. So you might need to do that for yourself if especially if you're trying for funding. Funding applications are really good if your case is in the public interest. And at the moment, I know there's a push to get all of the lending laws changed again so that the banks can have their wicked way with us again. But there is still in the legal system this idea that no, the Royal Commission actually did uncover a lot of fraud and criminal activity by the banks. So, if you can put your matter together in a way that highlights that there was fraud, if we can get this in front of a court, the court will see the fraud. It's amazing how much information you've actually got already. And the reason I've done this particular video, which, let me just see how long I've been talking for. Yeah, half an hour. Not bad. So, because these things are so complex, sometimes the fraud is actually in all of the different ways that they've done to hide what's happening to you. And while there's a general attitude, like you will, if you go to your average lawyer and say, I want to plead that, the bank committed fraud on this, or that this person did fraud. It was fraud. I should not have lost anything. It was fraud. They all step back and they go, oh, yeah, we shouldn't plead fraud. Well, actually, if there's fraud, you plead fraud, but you shouldn't plead fraud if there wasn't fraud. And fraud has got a distinct definition. So you kind of have to look at all of the issues. Let me just see if I can... Oh, I'll look at that. You can see everything I've done now. Oh, no, you can't. Ha! Because it's only showing... Gee, I must have set this up really good. I must have done. I've only got it showing that particular thing. Okay. So I'm not going to show you because, yeah. But I'm going to read out what the West Australian Police Force says about fraud. So fraud has been identified as the most expensive crime category in Australia, with fraud and deception-related offences believed to be the largest category of all federal offences from all levels of Australian courts. So the first thing you know is the fraud is actually a federal offence. So why can't we get the federal police to look into fraud? It's tough with the banks. The banks have a really big network, and I mean, with their billions of profits every year, they've got very, very large pockets. So, very deep. So only 25% of all fraud cases are reported. And I mean, this goes into all sorts of things. But so there's a financial crimes squad. So if you reckon there's fraud in your case, the financial crimes squad leads and directs the West Australian Police Force response to complex and significant financial crimes, which include, shall I read them all? The financial aggravated stealing offences such as stealing by directors, servants, that's employees, and agents, as well as other serious offences analogous to stealing. So when a bank sets up their loans, like we're going to go back to buyer beware, so caveat emptor. And back when we were going through court with our thing, it was very common for lawyers to stand up and say caveat emptor. You know, they knew what they were getting, which is fine. When you borrow money to buy a house, you know that you're going to have a mortgage, that you've got to repay it, blah, 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 blah. What you don't know, the things that they hide from you, is that they knew where the trouble was going to be, that they made promises to you that they had no intention of keeping, and I couldn't get that into the court. My bank manager made promises to me, flat out said, yes, that will be in the contract. Our contract was 4 days late in coming through, and it was like a day to settlement. So we were pretty much, if we didn't take the loan and didn't settle, then we were screwed anyway. So we were screwed at that stage, whether we took the loan or not. And we had done our research, and the bank manager said, your loan is a personalised loan. We've negotiated this. We have put in all of these things for you. And then when we got the contract, it wasn't in there. And it's like, well, what do we do now? Well, we sign. Because not to sign is also a problem. So that was one of the first bits of fraud. And I couldn't get that in front of the court. It's like, but I was promised all of this stuff, and I don't even think it made it into the affidavit. And I had a real problem with the affidavit. I reported the lawyer for the affidavit because I thought it was a lie, and you're not allowed to lie to the court. I could have been done for perjury, in my humble opinion. I still maintain that today, even though now I'm a lawyer, and apparently it's all right to do that. It's like, no, it's not. You can't tell me it's all right to do that. But anyway, apparently it is. And what we didn't know was all of the conversations that were happening behind the scenes between the bank manager and the bank. So we didn't know. There was a second loan application. The bank knocked ours back. We didn't know that. We found that out in a confidential hearing. So we had a conference, and it was all under the guise of confidential. You can't use anything that comes out. And that's when they said there was a second loan application. And we're there. There wasn't. Oh, but you can't use it because they said it in this conference. It's one of the tricks of the trade. They've done it at another conference that we had, where we had been asking how much the payout figure was. Well, how much do you reckon we still owe you after you've sold off our 2 properties? And we still owed more than what we'd owed when we originally borrowed. How is that possible? Well, they were charging compounding interest rates at the highest possible rate. Even though the interest rates at that stage were down to 4%, we were charged something like 16% on a relatively small sum, and they had undersold the properties and then just contrived this mega bill that we still had. And then they didn't give us that figure until a conference. And then it's like, well, we asked you for this for ages, and then we can't use that figure in any future trial because they hadn't given it to us. And it's like, no, this is stuff that we would have found out anyway. It's like we would have found out about the second loan anyway if we'd seen all of the documents. And it's like, well, no, you can't use it. These are the things that drove me to get a law degree. It drove me nuts. It's like, that's not what the law's for. That's not fair. That's not right. It's not justice. So, I do tend to get a bit upset about all of that stuff. So fraud also is to gain a benefit or cause a loss. Now, when we got our loan, there was a financial benefit to the bank manager. It was the acting bank manager committed the fraud, and she had a direct benefit because her bonus, her end of financial year bonus, was directly linked to the value of the loans that she wrote. And she wrote our loan like a couple of months before the end of the financial year. And she got a bonus for that. And then that loan was the direct cause of our loss. And even on the documents that the bank had for the second loan application, they still should have refused it. And they didn't. So that's them still going ahead. But that's all right. They took all of our property as security, and then they sold everything. And they sold it under value. Had they sold one property at value, it would have cleared the debt. All of it. But they didn't do that. And, you know, the first property that they tried to sell, they reckon they couldn't sell it, and I think they did. They sold it without all of the subdivision approvals in place, which dropped its value significantly. Had they actually done it with all of the approvals that were on the property, it was ready to subdivide. It was ready to go. Everything was in place. We could have started subdividing 4 months before we lost everything, and the bank wouldn't let us do it. So, and you'll find that a lot, that the banks actually stop you helping yourself get out of trouble. So it's just a dodgy thing. So when you're like me and you try to, or a lawyer who has somebody come in, the reason it's so expensive to get a legal advice by this stage of proceedings, when there's a lot of history, a lot of documents have been created, there's a lot of information to absorb. And I'm telling you right now, if you think anybody can read a complex document in one sitting, understand it completely, and give you an opinion on one document, yeah, you're dreaming. If you then think that they can do that with 1,000 documents that may or may not be relevant, you're really dreaming. Lawyers charge per page read. I mean, a lot of the top lawyers, they can pick it up immediately. But to actually put together the big picture when it involves 3 or 4 documents that are 300 pages long, it's more challenging. And all of their experience in the world doesn't make up for the fact that they will reread those documents, and they should reread them, and they have to read them all. I mean, the first read through, it's just a glance through, looking for the trigger words that they know are there. You know what you're looking for, and after you've seen it for a lifetime, you know what you're looking for, and you know what's not there. If there's certain information that's missing, you know it's a red flag. So it costs a lot of money to get the lawyer to know your case, and the lawyer to then write a brief for counsel for an opinion, because you really want counsel opinion, and then you really want counsel to do the court stuff. And this is where it's really tough fighting the banks. Because the banks hold all of the cards and they literally throw everything at it. In our case, I ended up having to do another affidavit because I'd actually been a bank employee like 10 years before we got this loan. And I ended up, the lawyer phoned me in a panic and said, "Oh, please, Rosie, tell me it's not true." And I'm like, "What? What's not true?" "Oh, tell me you've never worked for the bank." I'm like, "Hang on a sec." And it had been 10 years. And I'm like, yeah, actually I had worked for the bank, but it was only as a casual employee. I was a replacement. I'd get called in. The longest I worked there in any one stint was 10 days while another woman was on annual leave. I didn't do a lot. And so I ended up having to talk to him for hours. about what this was. And of course, you get charged for it. You get charged for every minute of those hours. And they put together an affidavit, and that costs money. And then in court, the bank's lawyer stood up and said, well, you know, she used her position in the bank to ensure that she got this loan across the line. And I'm thinking, what? And he goes on to explain that because the bank manager was so young, you know, that the bank manager felt that, you know, I manipulated the bank manager. And always said the bank manager, never said he or she. And we always thought that it was the bank manager, not the acting bank manager. And I should have picked up that there was something a bit odd, because always said the bank manager, whereas it was the she who was the acting bank manager who had done all the bad things. But apparently, while I was working at the bank, I manipulated the bank manager in another branch to give me a loan. So what this barrister, essentially, when I say barrister and lawyer, he was a lawyer who's a barrister. You can act as a barrister if you're a lawyer in Western Australia. But he was specifically employed by the law firm as a lawyer barrister. Anyway, so what he was saying, what he was telling the court, is that I am so brilliant at manipulation that I got a bank manager who at the time was in high school at the most. I manipulated this poor bank manager as a child to give me a loan later when they finally worked at the bank. And so, really? God, I'm good. I am so good, I tell you. I've got this whole manipulation stuff down. But I still love the judge's response. He sort of put his glasses down and he looked like that. And what's the relevance of that on you? But it's mind-boggling what the bank will do in court. And I mean, do I blame the lawyers? No. Their whole career depends on that. It's why a lot of people won't work for the big firms that represent banks, because it's selling your soul to the devil. And I think the reason why so many of them leave is because it does burn you out. You know, we got an apology from the lawyer when we sued the bank for damages. The bank settled out of court. We got a pittance back. It nowhere near our losses. It was bullshit. But, and I remember the look on the bank manager's face. This was a Perth bank manager who, you know, did his best to, you know, he's called the toe cutter for a reason. But the look on his face when another lawyer who'd originally had our case, he apologised to me and said, you should never have gone to court with this. You should never have gone through all of this. And, I mean, I appreciated the apology, but it's beside the point. We're still broke. Well, yeah. It's not going to be a fun retirement, so I got to get working on this, you know, writing my book and getting things done. Anyway, what I've got on the screen now, and it goes to how expensive it is and all the rest of it. So this is the report into AFCA, and the AFCA replaced FOSS. So it used to be the banking commissioner was the ombudsman for the financial services. Ombudsman, they called it FOSS. They used to always rule in the bank's favour, which doesn't seem to have improved under AFCA. So AFCA was the replacement brought in after the Royal Commission, and it just, I've been talking to people who've gone through AFCA, and AFCA just, it's like another blind eye, and people don't have a lot of recourse with the banking. It's, if you go to APRA only looks at what the bank's done, doesn't help customers. AFCA, which is supposed to help customers, seems to just rubber stamp all of the bank stuff like FOSS did. It's, well, what's the difference? May as well just have kept FOSS because it is useless. But anyway, I've pulled up the report into AFCA. It's only 58 pages, which kind of surprises me. But, you know, they recommend that the Australian government establishes an industry levy that would apply to the largest financial institutions, so that, you know, it'd raise funds for the legal assistance and financial counselling sectors, so that they can provide assistance. Oh, look, my husband's getting another one of those Amazon calls. But, you know, does it really help? I don't think so. One of the women who's contacted me, she contacted me earlier before she took her matter to FOSS. She says, you know, FOSS came back with, no, bank did nothing wrong. And I've seen what the bank did, and I'm telling you the bank did something wrong. That's rubbish. And the bank paid for her lawyer, and her lawyer was really good at first. A brilliant assessment of the fraud, you know, what the bank did wrong, blah, 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 blah. But now that the money's run out, she sort of says, no, accept it, and, you know, this is the position. But that's not the position. It's like, what happened? And I mean, I can't fault this lawyer's assessment of the case. It's really good. I don't think she missed. She might have missed one thing, but we're going back to, well, what's worth fighting? Is this worth arguing? And I'm thinking, yeah, probably not. So, you know, what happened between the beginning and now? And I've got some theories, which I won't raise on here, on this one, simply because I'm just trying to get across how confusing it all is when once you get a matter in front of you that's got so much history, where there's so many documents, and it's never ending. And I mean, one of the people I've been talking to, they were self-representing, did a fabulous job, really good. And when they got a lawyer in that they got funding, they got a good deal of money to fight this. And on the day, I mean, I was in court, and it's like, why are you conceding this point? Why aren't you arguing this point? What's this? And then I read the judgment, and the judge seemed to do mental gymnastics trying to fit his narrative into this thing to give the bank a win. And it's like, but they proved that the bank knew what was going on. The bank was complicit. And they ended up appealing it on their own. The law firm that they'd hired didn't want to keep going, so they appealed on their own, and they had a 3-day trial, and they won their appeal. It was, you know, it was just really dodgy. So now they've got another go at it. So they've had their first conference, but I haven't heard what happened yet. I must get a hold of her and ask. But it's really difficult to really put it all together and simplify it, because you really got to take all of this information and cut it down so that it's a logical argument in linked paragraphs. So, you know, we're addressing this. And one of the complications is bankruptcy. If you've been bankrupt, you've got to prove standing. And one of the things I've noticed is a few people I have spoken to they've either been advised to declare bankruptcy really early by their lawyer, which is something, if you were to ask me, I wouldn't give you a professional opinion, but I'd give you my personal opinion, and we did not go for it. Our lawyer said, just declare bankruptcy, it'll all be over, and we said no. A, we didn't do anything wrong, and B, bankruptcy is bad, and I don't care what anybody says. Bankruptcy is bad. It has a long-term impact. And these people who accepted legal advice that they should simply declare bankrupt before anything else happens, then ended up not being able to pursue their case, because the case is now the bankruptcy trustee's issue until you're a discharged bankrupt. Now, these people are discharged bankrupts. They've got a date. They've got letters from the bankruptcy trustee to say, no, nothing to do with us. They're discharged. It's fine. They've got the right to sue again. And the banks argue, no, they don't. They're bankrupt. We will only deal with the bankruptcy trustee. So you're spending a lot of time arguing that particular thing, and people aren't getting very far. And it's a frustration for me. And you have to literally address that in a separate section. You know, this is what the bank's saying. This is the position from the bankruptcy trustee or the trustee in bankruptcy. You know, we've got to put this to the court, and the court has to rule on it. And then you really have to chunk everything. And it's hard and it's frustrating, and it's not really a fun thing to do, in my opinion, because you know that people have been screwed over, and you know their life does depend on it a lot, because that's what they do. Anyway, there's all of these recommendations that they've put in, but what really sort of gets me is, you know, it doesn't say, you know, they make shit decisions, how about we fix them? It's like, okay. That's what I would have liked. But see, I don't like recommendation 10. So the committee recommends the establishment of a retrospective compensation scheme independent of the Australian Financial Complaints Authority to allow victims of alleged misconduct by banks who received a past external dispute resolution determination or court judgment that was manifestly unjust to apply to the scheme to have the matter reviewed with the consent of the bank. And what I don't like is the consent of the bank, because it's bullshit. They're the ones doing it. Why are we asking permission from them? Please, sir, may I have some more? Yeah, don't like it. I'm fine with all of it, but with the consent of the bank, I think that is really bad. Just my personal opinion. Look, I know that I've gone on a bit, as you do when you're me. So look, it's just a bit frustrating. I might even look at AFCA a bit closer in one of the videos. I'll see how I can... The reason why I have trouble putting this together, other than the fact that I'm in a lot of pain and, you know, really can't sit well. I find it really hard to figure out what people really need. I know people, it's this whole thing, that they need actual legal advice, and because I can't give legal advice, I can help put together some information so that you can have a shorter document. So do I want to deal with that in these videos? Do I want to make them freely available? Do I want to put them behind a paywall so that, you know, I get some sort of payment for my work? But, you know, I sort of think, you know, one to many is a really good idea. So how detailed does it have to be? I think it needs to be something like a webinar where I go through all of the different ways to approach it and actually have, you know, my documents ready, and I show you how to do things. So how would you put together a brief for a lawyer, so that you're looking for a lawyer? You know, I need to have possibly a webinar. How do you instruct a lawyer? How do you get the important things across before the lawyer shuts off their mind and already starts figuring out what your defence is, or you don't have a defence? It happens really quickly because lawyers are trained to do that. Lawyers tend to, some lawyers here, you know, my bank's done me over, they immediately go to unconscionable and then look for the bits in your information that go to that. And we want to avoid that in how to instruct a lawyer from the outset. So I think I'll do a webinar on that, and I think that one will be behind a paywall, but I'm not sure what level. Like Patreon has 3 different levels, and, you know, how much do I want to put at the, you know, say the $9 level or $7 a month or something, where you get the information before it goes onto YouTube a month later? I don't know. I'm working on that. But, you know, how do I teach you how to do these things for yourself? How do I explain costs? Because costs is a big thing. If you lose, and you lose your appeals, and, you know, there was a case of someone who wanted to prove a point about securitisation, which is an interesting topic in and of itself. But it turns out that the bank hadn't securitised their property, and then they ended up losing the property, which wasn't at risk at the time. They simply stopped paying the mortgage because they wanted the bank to act. Or that's my reading of it. I could be wrong, but that's my reading of what happened in this one particular case. I might see if I can find it, to see if I can find all of the litigation history and what claims were made. And I read it on their own personal blog. So I might see if that still exists, if I can find it. This is going back 8 years, so if I don't find it, it's not because I'm not looking for it. It might be because they've taken it down. But because the bank actually hadn't done anything wrong, and they could afford to pay the mortgage, but they stopped paying the mortgage because they wanted to prove this point. It just meant that they had to pay all of the legal fees because they caused the issue in the first place, and the legal fees were extensive. So I think I need to do a few videos on costs. So I'm thinking I'll do some basic ones, like 5 or 10 minutes, just to cover off the big stuff, and then I'll do some long ones that some of them might be released a month after I've put them on Patreon, and then some after that they'll stay behind the Patreon walls, so that people who are prepared to pay something like, you know, $25 or $30 a month can have access to them at any time they need. As I say, I want to make this side of it financially viable so that I can do the other work for people who've got no money for free. It's because I can't give legal advice. If I could give legal advice and work as a lawyer, I would have them pay a reasonable fee for service, and I would put together a counsel brief for them to take to and then instruct a barrister. From my understanding, they haven't changed the law yet. They're looking at allowing self-represented litigants to be able to instruct their own barrister. Some jurisdictions you already can, so rather than putting together a brief for a lawyer, you would put together the brief for counsel, so that the barrister can give you a legal opinion, and then you can work with a barrister to run your case for you. And I think that's a pretty good way of doing it, actually. That way you're getting the oversight of a barrister who can help you much better than a time poor lawyer who is under immense stress to do their own thing. And as I say, they don't really like people who've ever self-represented, because self-represented litigants can be quite tetchy, very tetchy, and some of the advice just doesn't get through. And I can understand that. I have a lot of empathy for people who go through this stuff. Having been there myself, I can totally get it. So anyway, I think I'm going to wrap this up. I might see if I can get my Patreon up and running. I haven't done it yet. As I say, I haven't been able to sit down, and I've been on some really cool painkillers. That meant, don't ask me what I've done for the last 10 days, because who knows. I've been lying down a lot. I kind of sprained it again the other day when I sort of slipped a little bit, and wasn't pretty. Back on the painkillers, and not much fun. But I'll see what I can get going. I will put a link to the AFCA report for anyone who's interested in actually reading it. I will probably do a breakdown of it. As I said, I love this whole thing of having the compensation scheme. I just don't like the consent of the bank bit. There's not much happening that I have been able to find on YouTube about the banking stuff now. There were a few people who I know are still fighting the banks, but they're not putting the information out. This isn't legal advice. This is just common sense advice. Don't put stuff on social media. Don't name names of bank managers that you're accusing of fraud. It's not that I want to protect the banks. It's simply you can get done for defamation of an individual, even though you can say the bank defrauded you because they've got more employees. You can't actually name the individuals. If it comes out in a public document, then it's open for debate. Might be found guilty, might be found not guilty, whatever. A news story might come out about how, they've been accused of fraud numerous times, and this is, the modus operandi. I'd still keep it really low-key. I think that we had a better result with the bank because I actually started a blog, and I started writing about it, publishing it on my own website, discussing what the bank was doing to us and what I expected the next move to be. And the bank never moved to bankrupt us. They didn't do a lot of things to us that they did to others, but that's because I would talk about it on my blog. I ended up taking my blog down, and I feel like a sellout over this because the Legal Practice Board asked me to. They said, unless you get rid of it, we're not going to allow you to practice as a lawyer. And I'm thinking, I did 18 months part-time. I'm kind of feeling ripped off that I sold out my principles for something that didn't eventuate anyway. But still, I'll see what I can do with what I've got on the go. Hopefully I'll start to feel a lot better soon, and I'll be able to start working on all of this properly, because I think this deserves as much effort, if not more, than my blog did. And I will, I'm going to get this going again. Some of my blogs will end up being on Patreon. If I do a short blog, I'm thinking of starting a website for Lady Rose, Legal Briefs. If I'm going to put anything behind a paywall, I'll put the link into the blog itself. I do want to keep a lot of information free, but as I say, I do need to make money. I have to replace an income. I haven't worked since we left the farm. I've worked for 18 months part-time as a lawyer, and studied for 5 years. It's not good. I need to work, and it's not that I'm not applying for jobs, but I guess I come across as a really strong, opinionated person who's got a bit of information out there. I'm also older than most people that would hire me, so there's that. But I would really rather see if I can make money out of this, so I'm going to really work on it now. So I've got my hour and 7 minutes up, so talked a bit longer than I intended. I'm going to work on timetables for when I'm going to do lives. I intend to do lives for just on YouTube regularly, and I want to do the paid subscription ones twice a week, so that there's some value in a paid membership if that's what you choose to do. And I'm hoping to get a YouTube shop going, so that if you don't want to be a Patreon, you can buy the occasional thing, so that I make some money. I mean, I wouldn't make much. I think you'd only make about $3 or something an item, but every little bit helps. So I'll see what I can do. I will pretty much, hope to stay off the painkillers. Hope to get my brain back. It's still not feeling pretty good. Hope to be able to sit longer than half an hour without starting to feel it. And hope that I'll start to make more sense as I recover, and I do these videos with a bit more thought and effort. As I say, I only put this one together so that I'm still here and I'm still plodding on. It's just very slow at the moment. So have fun.